Hi, Steve Riley. Welcome to this episode of Great Practice, Great Life. Today, I'm talking to you about the 3 challenges of embracing AI, the steps to get your law firm future ready in your practice today. So, I have the privilege of being solo in today's episode. I have no adult supervision. It's just you and me talking about you, your practice, and the future. That's what today is about. Now, I know the topic of AI is overwhelming. And if you're a solo practitioner, you're a team leader, if you're in a team, the question starts to become, how do I cope with the growing pressure of AI? Now, the first time I talked about AI was probably 2012. And when I first discussed it, and we'll put a link in the show notes about a YouTube video where I made 5 predictions about the legal industry in 2012. And I'm not too far off. Those predictions were pretty much on the money. And you'll see me with different color hair and more of it. So it's a fun YouTube video to watch. But the question really is about you and how to think about AI. How do you, with everything else you're dealing with, how do you make AI work with your practice when you're feeling overwhelmed 99% of the time? I mean, how can you squeeze in another darn thing to learn in your practice? That's really what I'm here to talk to you about. This is from my favorite futurist, or one of my favorite futurists, I should say, a guy named Ray Kurzweil. And Ray Kurzweil, in his book, The Age of Singularity, which he's now updated, has this great quote, and I'll read it to you. 2029 is a consistent date that I predicted for when AI will pass the valid Turing test and therefore achieve human levels of intelligence. I'm going to pause there for a second because there's some people that have argued that AI has already passed the Turing test. Google has made this argument. A couple other companies have made this argument. The Turing test is basically a test by which when a human being interacts with AI, the human being doesn't understand that they're interacting with AI. They think they're interacting with another human being. So the ability of AI to pass itself off as another human being is really the core of the Turing test. So there's a couple different variations of it. That's kind of the argument about it. Here's the interesting thing that Kurzweil says. I've set the date 2045 for the singularity, which is when we will multiply our effective intelligence a billionfold by merging with the intelligence we've created. Kurzweil's argument is in the year 2045, the human mind, the human brain, will integrate with AI, and that's what he calls the age of singularity. Incredible, incredible premise. I don't want to spend too much more time here, but I just want to let you know Kurzweil has about an 85% success rate. So let's be very straight. AI is here. And if you're in the legal industry, you have to comply with new ethical rules. About 20 jurisdictions have come out with ethical rules. There's 50, there's obviously other jurisdictions that have not. The jurisdictions have come down in different ways, in different interpretations. Some have guidance, and the guidance is pretty broad based, like don't do anything stupid, be aware how AI works, and protect client confidentiality. I think it really distills down to a couple of key areas, and I just want to talk practically about this. So regardless of your jurisdiction, one of the things I want you to be aware of is that you have to get client consent for the use of AI. So if you have not updated your engagement letters, I'm going to encourage you to immediately update your client engagement letters to confirm and disclose to your clients that you're using AI tools, and those tools are designed to help better your representation of the client and that they're consenting to the use of those AI tools in writing. 1 or 2 sentences, because most of the more draconian or more direct bar rules, Florida, Pennsylvania, a couple other jurisdictions, are pretty direct. You have to have client consent. Now, I'm going to encourage you to consider that client consent, not in just new cases, but in all cases. So that means if you have active cases going right now, you want to check your rules because you may be required to have your client's consent today in active cases where you've already been hired to the use of generative AI in their representation. So if you're working on a case and you're using generative AI to summarize an email, summarize a deposition, to write a brief, to write a contract, and you haven't gotten the client's written consent for the use of it, you may be in violation of the rule in your jurisdiction. Number two is that certain jurisdictions require competence and oversight. Pennsylvania, Florida are pretty aggressive here, where they're expecting you to have some level of understanding of AI and some level of competence around the use of AI. And that competence is ongoing. So from today to this point in future, you need to have some understanding of how AI works. So you actually now have an ethical duty in certain jurisdictions to be competent in the use of AI, to be updated, stay informed, and aware of the ethical and guidelines, how to profit or not lose money. Look, if you're in the contingency fee business, PI, disability, it doesn't matter. Or you're in the fixed price business, generative AI is going to be awesome because it's going to allow you to do things quicker, faster, cheaper. The ones that are going to have the really, really difficult time are the folks that charge by the hour. Goldman Sachs did a study that they're estimating 40% to maybe 45% of billable revenue inside of billable practices will be gone due to generative AI. I think it's an underestimated number. I think it's probably going to be closer to 50 to 60%. Here's how I want you to think about this if you're in a billable practice. When I was a young litigator, I would get assigned a 500, 600 page deposition. My job was to summarize that deposition for my boss, show them, put together kind of a notebook showing them where there were certain things that they could do on cross-examination and trial, showing where there's bias, showing them certain things in that deposition. Now, it may take me 10 hours to complete that. If I build it $200 an hour, that's $2,000, right? You can do that in ChatGPT or CoCounsel in about 15 minutes. It's amazing. Now, that doesn't mean that you won't read it, you won't review it, you won't do these things, but I think that the billable hour practice is going to be so severely crushed by the new ethical rules around what you can bill in a billable practice, that if you're in the billable practice and you're not paying attention to what's happening, you're going to be in a very, very difficult position in 1 to 2 years. So let me just review 5 areas very quickly to think about: deposition summary, legal research and writing, record reviews, drafting legal memos, contract drafting. So if you haven't seen Spellbook, I would encourage you to go to YouTube and watch Spellbook, how Spellbook works. There are going to be so many ways that some of the billable work that we used to do in law firms is gone. Now, does that mean that we're out of business? No. It means that certain ways that you generated revenue will be gone. So it requires you to rethink your business model. It requires you to rethink a lot of different things about your practice, which is really the purpose of this whole conversation. I want you to really think, how am I going to address this? What's my strategic plan?